All right, next up, we are going, in the interest of time, to combine the next board, and if we could have both members just come to the table and sit at the table, and then if both senators could jointly give their nomination. That's Senators Reedy and Zucker. This is the Handgun Permit Review Board for Mr. Charles Holman and Ms. Shari Lynn Judah.
That's okay, everybody.
Excellent.
Does that?
Thank you. And if you all maybe could take a seat so that we could just do it jointly. And if senators have questions, if they could address the individual nominee. But Senator Reedy, if you could please go first.
Yes, sir. Thank you, Mr. Chair and members of the committee. I'm really honored to have the opportunity to support and introduce Charles Holman to you for a position on the Handgun Roster Board, Handgun Permit Review Board. I'm sorry, Handgun Permit Review Board. Charles is a long-time serving attorney in Carroll County, in excellent standing with the Bar Association. He's been had experience in a number of different areas of the law, but he's also been a long time very involved in our community. Lives in Hampstead, and is I think an excellent appointment. Very straightforward person with a lot of integrity to be in a position like this. So I'd give him my full endorsement and ask for your support.
Thank you, Senator. Senator Zucker.
Thank you very much, Mr. Chairman, Madam Vice Chair. It's my pleasure to present Ms. Judah, who is a small business owner, and she's been very active throughout District 14, and I appreciate the opportunity to be able to present her this evening.
Thank you, Senator. Mr. Holman, anything to add?
Mr. Chairman, Madam Vice Chairman, it's a privilege to be here, to have the opportunity to appear before you. I do request your confirmation. I would like to thank Governor Hogan for his appointment, Secretary Moyer for his confidence in nominating me.
Thank you. Ms. Judah?
Thank you very much. I'd like to thank Governor Hogan for the appointment, as well as Secretary Cavey, and I'd like to thank the Senate committee here tonight for giving me the opportunity to be considered. Thank you very much. It's an honor and a privilege to serve the state of Maryland. I love Maryland. I was raised here, and I was in California about 10 years, and I missed it so much I had to come back to raise my 4 beautiful children here, and I did just that, and it was definitely the right decision. Thank you.
Thank you. Questions? Senator Medellino.
Thank you very much, Mr. Chairman. In your work on the Handgun Review Board, do you believe the state has the right to keep someone from having a permit?
Is that for?
You go first.
Let me go first. Does the
Can
state?
you swing the mic toward?
I'm sorry.
There you go.
Okay. As I understand your question, does the state have the right to keep someone from getting a concealed carry permit? They do indeed have the right under the statute, and our job is to implement the statute as it now exists, Section 5306 of the.
No, but can I ask, do you believe the state has the right to do this?
Well, having been a practicing attorney for over 40 years, I can carry out the provisions of the law regardless of my personal beliefs. The oath that I took to act on this board is to carry out my duties without passion or prejudice, and I think I can do that.
Yes, I believe I took an oath under the Constitution to uphold to the very best of my abilities, and I respect that.
So interestingly, though, the position that you're given is you're actually provided the opportunity to weaken the law by overturning all of the decisions that the state police have made about denying someone a permit. So I was wondering what, because obviously you can decide whether or not the person has, I believe, a history of violent action.
Yes.
Or that they have a threat to themselves? How do you, if the state police have said, no, we can't find a threat, or yes, we have found a prior record of violence, what do you use as a guide to second guess the judgment of the state police?
Well, go ahead. I'm sorry.
Let me take first bite at this. First of all, our job as a board is to conduct a de novo hearing on the application that has been filed before the state police. All of the applicants that come before the board have been fingerprinted. They've subjected themselves to a criminal background check, not only in Maryland but throughout the country. They've completed 12 hours at a minimum of training. They've completed proficiency work at a range. And when they appear before the board, each applicant appearing before the board has the burden of demonstrating by a preponderance of the evidence that they are entitled to be issued a wear and carry permit in the state of Maryland. So the way that the board proceeding works, if I may, to fully answer your question, is that the Maryland State Police first make their presentation to the board. They submit evidence, testimony. The applicant has the opportunity to question the Maryland State Police. Then the applicant has the opportunity to present evidence and testimony. The state police have the opportunity to cross-examine the applicant. And after all of the evidence has been submitted to the board deliberates and issues a written decision based upon the evidence that was presented to it. And following that written decision, if the applicant is dissatisfied with the finding of the board, the applicant has 30 days to file an appeal to the circuit court, and the same applies to the Maryland State Police. If they are dissatisfied with the decision of the board, they have the ability to apply or to file an appeal to the court as well. So before our board, it is the record that is made that tees this up if there's if a party's dissatisfied to take it to court.
But that's your last point before we get back to Ms. Judah. Your last point there about the state police can challenge, can appeal your decision to overrule them. You, as the decision maker, are thus represented by the Attorney General. Who is going to represent the state police to challenge your action?
Well, mechanically, we have an assistant attorney general who advises our board regularly when there are questions that the board has. That young man who who's available to answer questions for the board does a fine job doing that. His name is Mr. Ben Legum. As far as taking an appeal, it would be the Attorney General's office. They would select an individual other than Mr. Legum to take an appeal into the court if they felt that the action of the board was inappropriate.
So the Attorney General would represent both sides of the case?
Probably. It would be different individuals in the Attorney General's office. But once we render our written decision, like any other administrative agency, our job is done.
Do you want to go back to that question?
What your original question is how do I come to the decisions that I come to?
Mm-hmm.
Yep. Well, we get the cases beforehand, and I like to get as much information as possible. I read and study the cases. If I have any questions, any issues of concern, I'm very vocal. I bring it up at the meetings, and I'll ask the Maryland State Police, or I'll ask our attorneys present, or the applicants, or fellow board members.
So how do you judge when an individual comes before you and says, while the state police say, I cannot provide documentation that I need this permit, I am fearful and want it for self-defense. How do you judge? Because there's case after case.
Every case is individual. It's a case-by-case situation. I can't make a generalization on that because each case is different, and it depends upon the case, sir.
So in a case, there was a case where you had someone who was an EMT with the Fruitland Fire Department, if you remember this case. So the
Can you
state
refresh
police.
my memory?
The
Okay,
state
go ahead.
police said no.
Right.
To him.
Right.
That he had shown no documentation. He could provide no evidence that he was fearful, that he had a reason for a permit. His supervisor at the fire company told the state police that he could not, that they are not allowed to carry weapons while on duty.
Right.
All he was able to provide apparently was just articles showing the increasing impact of the opioid epidemic.
Right, and I'm not quite certain which case that you're referencing. However, I don't know if that was in regards to his restrictions being lifted, or was it to get a conceal and carry permit? I would have to have the case before me
Okay, it was
to
a
understand and look at what the reasoning was that I made the decision that I made.
all right. So, but
It's case by case. I mean, we've had so many different cases, and I'd have to look and see. It seems that you're talking about anxiety-ridden, that he feared for his safety, but he didn't have proper documentation according to the Maryland State Police. Is that what you're saying, sir?
yes, in that case, yes.
Sometimes in different cases, they do produce documentation. Or
And what would be
there's different situations. It's a case-by-case thing. For example, an emergency, you're talking about an emergency EMT that's coming to the scene of a crime, perhaps, or a drug overdose or something of that nature. They're wearing a name tag. It says their name. They also are going to be named on the police report. And some of these individuals reside in the same towns and communities that they're going to these crime scenes and going to these drug-related situations. Therefore, it's a case-by-case basis. It's all the individual case and the circumstances and the documentation. If ever I have a question, because I'm a private citizen, I'm not a legal expert like Mr. Holloman is here. I try to ascertain as much information as I possibly can and try to ensure that fair and due process has occurred. And everyone has been very amenable to that. The Maryland State Police have been amazing, and so have the attorneys. And our board members have been very helpful, and our applicants too.
So it's just on a case-by-case basis?
It is. It is on a case-by-case basis. There's no way I could make a generalization on that because every case is different and everybody deserves their fair and due process.
All right, thank you.
Madam Vice Chair.
I've been very concerned about some of your case examples of ways in which you've made decisions recently on this board, which is a very important board. And to read that a person who has to be denied, even by the 5-member board, is told to go get your case expunged and come back. This is one thing. Another thing is to hear that you would give a permit for conceal and carry to someone because they are a foster care parent. And as a foster care parent, they think they need to have protection from biological parents. Doesn't seem as if something's wrong there, and I would hate to think that kids who really technically are in the custody of the state of Maryland and who are vulnerable would be in a place where it sounds like somebody's expecting a shootout at the old corral. And that's not what ought to be a good environment for foster care kids. Could you tell us about some of the decision-making that goes on when you get situations like this that you have to make a decision regarding?
Okay. Senator, let me try to do those one at a time. The first, with regard to expungement, the legislature has worked on the Justice Reinvestment Act in an effort to allow certain circumstances where minor crimes under certain circumstances can be expunged from the records of individuals to help them out. Before the Handgun Permit Review Board and before the state police, we have to follow the Maryland law. And if I may give you just two examples of how that works. The first has to do with a statutory provision which expressly prohibits any individual who has been convicted of a crime of sale, use, or possession of a controlled dangerous substance or drugs. They are forbidden to have a wear and carry permit in the state of Maryland. So what happens when an individual who in their younger years, 20 years ago, in another state is arrested with a group of other young people who are smoking marijuana? This individual testified that he was charged with possession of marijuana, that was the extent of it. It wasn't with an intent to sell. That was a bunch of ornery boys out smoking marijuana. But they were charged. He was convicted. He pleaded no contest to the charges, and as a result of that conduct, he was prohibited and is prohibited from having a wear and carry permit in the state of Maryland, period. Some individuals may feel that that's a harsh result. That's not a judgment call for us. That's way above our pay grade. But it may well be that that minor transgression, by most people's standards today, is something that could be addressed with an expungement of those minor criminal records to allow that individual to pursue their application based on the merits.
Well, let me butt in and just ask you this. Obviously, the state police took a position that the person did not meet the current standard of the law in Maryland regarding this.
Correct.
And so they had been denied. Do you think it would have been better for this person to get private legal advice that they pay for or that they get from a pro bono source rather than for you as a member of this board working in an appellate position so you can overrule the state police to tell the person how to get around the law?
Well, it's not a get around. I will say to you that in my short period of time on the board, I have been surprised by the fact that so many applicants appear before the board without the benefit of legal counsel. Number one. Number two, and most importantly, any individual who is aggrieved by an action by the Maryland State Police has the right by statute to file an appeal to the board. So in that particular...
I don't doubt that. I'm just saying when they come before you, is it your role to give them legal advice, which is what appears to have happened, as to how they could get around it and then come back?
Well, ma'am, I'm very careful to never give free legal advice. But we don't give legal advice at the board level, but the individual in a case like that would appear before the board. The board did indeed affirm the action of the state police in that case, but the board makes every attempt to give good customer service to citizens of the state of Maryland. And we provide, we feel that it's our duty to allow them to have their day in court, so to speak. We treat them with dignity and respect. Frankly, I think that the case was a case where the individual should have sought counsel, and that's what we directed them to do so that they could address that. So we do our very best to advise people to seek private counsel, which in a case like that we certainly did.
Okay, well, I won't drag this out, but it sounded to me, from what I read, that you gave them counsel. And I thought that was not your role, since you're in this appellate position already with regard to the decision having been made by the state police. But thank you.
We do our very best to make people leave when they leave, to feel that they had an opportunity to be heard, that they had an opportunity to ask the state police questions, and that they had an opportunity to have us consider their particular circumstances with a clean slate.
Just for the record, ma'am? Ma'am?
Yes, please.
Thank you. I just wanted to know it is not my role to give legal advice. It is not my role, and I've never given any applicant any legal advice whatsoever, just for the record.
I want to be mindful of time, but I have a couple of questions, and I know Senator McFadden has a couple of questions as well, and Senator Ramirez as well. So I think one of the pieces of data that came to my attention is that over the last year, the board has overturned the Superintendent of State Police's recommendation at a rate double of what it was the prior year. So, the cases that seem to be overturned are remarkably similar to what were previously upheld the superintendent's position in the past. And I'm curious as to whether that is a product of the nature of the cases? Is there a sense of a more, less objective standard for what one deems as a good and substantial threat that one has, or is there a board position for why that rate of overturning of the state police recommendation has increased so much?
I don't feel that there's any sort of way to gauge that sort of consensus, because the cases are done on a case-by-case basis. Every case is individual, and we as board members do not have any control over the scheduling of these cases, when and where they're going to be heard. We just hear the cases. So to just take an example, you could have a hearing where you have several cases overturned, or you can have a hearing where several cases are sustained, or a mixture of both. So I think there's no way to ever make that generalization based on things being an individual case and case-by-case issue.
Fair point. Let me reframe that. Do you believe that it's an objective standard or a subjective standard when someone provides the threat or specified threat that they have? Do you think that the board should be looking at it from an objective standard or a subjective standard?
It is an objective standard, Mr. Chairman, but the circumstances are that we do our best to allow each applicant to have an opportunity to present in its entirety their case and their reasons. Many times, there's not a single reason why an individual feels that they have met the standard of having a good and substantial reason to have a carry permit in the state of Maryland. It may be a number of factors that weigh on the scale to making that decision.
Do you believe that an applicant or an appellant can meet that objective standard without third-party verified facts or without an investigation done, just that the applicant provides that to the board? Is that sufficient to meet that objective standard?
It's hard to say. It's hard to make a gross generalization, except to say that the board has the ability to determine the credibility of the witnesses. We have the opportunity to see the demeanor of the applicant and of the witnesses. that would appear, and it's a question of whether the applicant has met their burden of proof. Many times they fail to meet their burden of proof, or if they do meet their burden of proof, it may be based upon their testimony or circumstantial evidence or whatever. We try to take the time to give each individual the opportunity to fully present their case.
And so is that, I just want to make sure, is that a yes? You believe that somebody can meet the objective standard without third-party verification or submitted testimony and evidence from a third party that the threat is credible?
With no other evidence other than just their testimony?
Correct.
Probably not.
So there
Would need to be some corroboration, but it may not necessarily be that the applicant made a complaint to the local police department to get a police report as such. Then there are some common sense corroborations, such as an individual who may be a physician and has a prescription pad that he carries with him in his black bag.
So there was a recent case that you had earlier this month, in which there was a gentleman from the town of Denton who he was a code enforcement officer, had represented that his employer, the town, was willing to let him have a permit during work hours. Was later determined that that was not true, and then the appellant offered up the idea that other officers or other code enforcement officers had faced some issues with people, but not him specifically, and represented to the board that these other code enforcement officers could call police to escort them. And that was, in fact, what the town had recommended that he do in his position, and he would not be permitted to wear and carry a weapon while serving the duties of the town. And yet the board overturned the recommendation of the state police without any objective or corroborated evidence. So
Actually, there was evidence on that case. There were 4 different instances that the code enforcement officers were threatened.
To that specific individual?
It was on record.
To that specific individual?
To that specific individual, no. However, they did seem to, although they didn't request him to be armed, they did want him to take a police escort, which my common sense said that there was risk involved.
But Mr. Chairman, if I may, that case is still before the board. There has not been a written decision on it. It would be inappropriate for us to comment on that. But hypothetically, if the individual in a situation where he was a code enforcement officer, where he was enforcing housing code violations against individuals, and there were threats that were documented and sufficiently supported by some evidence that threats were made to other code enforcement officers, and if, hypothetically, this individual lived in the community and was known by individuals that he was going out and having contact with during his daily job, again, hypothetically, that individual may indeed have a good and substantial reason to have a wear and carry permit, assuming he has met all of the criteria, the background check, the fingerprints, no criminal record, the training, the proficiency, all of those things. He may be able to accomplish getting a permit.
Are you, just very quickly, are you familiar with the Snowden case in Maryland?
I am, yes, sir.
And that was a case that I believe suggested that there is not a generalized threat, that it wasn't a sufficient standard by which to meet the articulated threat
Right.
that rises to the level of meeting the statute. Your comments Do you believe that Snowden applies to the current or to the application process today?
Well, Snowden certainly applies. It's certainly the most. It's one of the recent decisions of the Maryland courts. However, the cases are very fact specific, and the fact specifics of the Snowden case are specific to that case. The board had the opportunity to judge the credibility of the witnesses, weigh the evidence, and do all of those things in the Snowden case. So it depends on a case-by-case basis whether the individual applicant would be able to demonstrate by a preponderance of the evidence, that's the standard, that they are entitled to be issued a wear and carry permit. If the board so determined, based upon the evidence and it deliberated and so found, and if the board issued a written decision, if the Maryland State Police felt that that was an incorrect interpretation of the law and an incorrect interpretation or application of the facts, they have the right to file an appeal. In fact, if they feel that strongly that we did something wrong, they have the duty to file an appeal to the courts and get further clarifications.
Is that a position? Do you believe that is the best? Is that the board's role to clarify, to set up opportunities for appeal to clarify the role?
Not at all. Our job is to do the best we can at applying the law in each and every case that an individual comes before the board, giving them the attention and respect that they're entitled to, and allowing them to have an opportunity to prove their case if they can.
One final question is the standard operating procedures that are issued by the Maryland State Police. Do you believe that they fully apply and are wholly lawful in the state of Maryland? Do you think that they are the applicable law in questions and matters that come before you?
They are applicable to the general procedures of the Maryland State Police. The board is not bound by the details of the standard operating procedures. That's the advice we get from our Assistant Attorney General. We find them to be very persuasive. We find them to be applicable in many circumstances, but there are some cases where one size simply does not fit all. I would like for the committee to be aware that the cases that are brought before the board are individuals who have elected to take an appeal because they're unhappy with some aspect of the permit, whether it's being issued a permit in the first place or whether it is a question about a restriction that was placed on their permit.
Senator McFadden.
Mr. Holman, earlier on you referenced your Attorney General and how he provides you with salient and important information. And just a moment ago you referenced him again. In one particular case in February I have in my possession, a Mr. Passett came before you who was a federal employee looking for a permit to hold a gun. And your Attorney General, on multiple occasions, advised against it. Again, I'm in the possession that you as Vice Chairman, the gentleman had the President of the Maryland Shall Issue organization support this request, and that your Assistant Attorney General on several occasions objected, but he was overruled, and you as Vice Chairman said you appreciated the testimony that the President of the MSI presented, and I guess the conclusion is, I don't want to be long with this, but that you as well as Ms. Judah supported that. Can you just talk a little bit about that?
The case that you're referring to...
February 7th.
Of 2017?
Of 2017.
Okay, I believe that there was testimony by a witness that was called by one of the applicants. The Attorney General, actually the Maryland State Police was represented by a separate Attorney General who objected to this individual testifying. Our Attorney General, our Assistant Attorney General, indicated that he didn't think that the testimony would be particularly persuasive to the board. He didn't think that it would be relevant. Allow me to finish, please. We felt that it was important to allow the individual to be heard. He testified. The applicant had the opportunity to have that individual be heard. He called him as his witness. When the deliberations took place, if I recall, I pointed out that the specific testimony by that individual, while interesting, it was not the basis upon which I made my decision as far as my vote on the board. And Senator McFadden, what happens many times before an administrative board is you have people come before the board whose evidence may not be particularly probative or particularly brief or particularly succinct to the issue that's to be determined, but we try to be as understanding as we can to allow them to have their day in court. And in your example, what happened is we listened. The particular testimony was not germane to the ultimate decision in the case.
Right. I remember that case. I felt that they got off course. They were debating with each other, but it wasn't in relevance to what was the actual appeal that the applicant was making.
So you two were not overly influenced by the Maryland Shell issue, President?
I was looking at the case based on what the appeal was, what the applicant was appealing. I remember that's where my focus is why are they appealing?
But this gentleman...
And they were, in my opinion, and again, I'm not a legal scholar, sir, and I will never pretend to be. I'm a private citizen.
I got you.
But they were going off topic. They were kind of, they were arguing within each other, but I didn't think it had pertinence to what the focus of, as what the decision was for the case itself.
So this applicant needed...
He chose to have counsel, which was his right.
He needed a gun permit, and what was his job? He worked for the Social Security Administration as an IT employee.
I'd have to have the case in front of me, sir, to see exactly where the gentleman worked.
That's employee in the IT office of the Social Security Administration. And there was it happens all the time in government, some sort of terrorist threat that was issued, and he felt that he needed a gun. And he brought along the president of MSI to testify on his behalf.
Right, he did, sir, but I wasn't particularly I was not influenced by his counsel's testimony. I was influenced by the applicant's testimony and the reason why he wanted a gun.
What about the testimony of the Assistant Attorney General, who also, who objected to this moving forward in this fashion?
Well, I think he objected, if I can remember correctly, because he did not feel it had relevance to the case. And that's what the going back and forth was, and they have 30 minutes to present their case. And so it was eating up the time, and we wanted to get back on the focus of why was this applicant here. Because I look at them, sir, they're applicants and not defendants. And I'm looking at, okay, why is this gentleman here? Why is he appealing? What are his reasons? And let's look at all the documentation and his testimony and the Maryland State Police testimony. Like I said, you know, Charles can articulate this much better than I can.
I'm going to tell you, you guys are so smooth. Boy, I'll just take both of you guys to court with me.
You think I am? Oh, goodness.
Oh, my goodness. Yes.
Senator, could I comment that we're not talking about a case that's now before the board and under advisement. we're talking hypothetically. The case that you refer to is indeed before the board. It's been preliminarily discussed, but it has not been ruled upon, so it's hypothetical that we're talking about the testimony of a witness. I understand. Thank you, sir.
Thank you. Senator Ramirez is not here, so I think we will move on without him. Are there any further questions? Thank you all very much for your service. Thank you.
Thank you very much.
Thank you.
Thank you.